I'd like to start off with a quote, and I think it really ties together very nicely with family law and family law litigation. Folks, do remember, specifically the guys who do commercial litigation, collections, etc. Family law litigation is a little bit different. Your approach needs to be different. We are dealing with people, we're dealing with one of the most foundational institutions of the human experience, being the family. So our approach must be different. And I really do like Abraham Lincoln's quote, and for those who are not aware, remember he was an attorney before he went into politics. He stated the following: discourage litigation, persuade your neighbors to compromise whenever you can. As a peacemaker, the lawyer has superior opportunity of being a good man. There will still be business enough. I really do like that ethos of saying, you know, we don't always necessarily have to fight. However, if we do have to fight, it is important to know what the trenches look like, and that is what we are going to be going through in this section, Introduction to Family Law Litigation. Right, so let's talk about family courts first, and I'm not talking about the recent invention in South Gauteng of the dedicated family courts. I'm talking about family courts in the broader sense. I'm talking about specifically courts that look after the families and family law matters. And I suppose no conversation on court systems would be complete without just first clearly delineating the difference between our superior courts and our lower courts. The top picture, you can see our South Gauteng High Court, in the bottom picture, right. So what is the difference between superior courts and high courts, and which courts fall into these specific courts? Superior courts very simply consist of the Constitutional Court, the Supreme Court of Appeal, and the High Court. Now, folks, in terms of family law skirmishes, when we talk about the superior courts, the vast majority of skirmishes will take place in the High Court. It is a court of first instance, and it deals with the vast majority of family law cases in the superior courts, for the simple reason that it is a court of first instance that is empowered to deal with a very, very wide variety of cases. The Supreme Court of Appeal also bears mention. However, understand that the Supreme Court of Appeal is, as the name implies, an appeal court. It is not a court of first instance. The Supreme Court of Appeal does not hear any trial matters. You cannot issue a summons from the Supreme Court of Appeal. In other words, what does it do? It hears appeals specifically from the High Court and the various benches of the High Court. Now, above the Supreme Court of Appeal, we deal with the Constitutional Court, which may be accessed directly, but it is very unlikely that you will see a family law matter being issued out of the Constitutional Court. In fact, I do not think they would allow you to. What would generally happen if there is a constitutional issue in a family law matter is that would be raised in the High Court, and you would do your necessary Rule 16, etc. notices, raise the constitutional issue, and then it would be either rubber stamped or not rubber stamped by the Constitutional Court. So, folks, for today's discussion, when we talk about the superior courts in the context of family law litigation, the overwhelming majority of times that we mention the superior courts, we will be talking about the High Court. Now, if we go on to the lower courts, just by way of introduction, we find the regional court of the Magistrates Court, we find the district courts, and then finally we find the Small Claims Court. Small Claims Court obviously are very, very tenuous relevance to family law matters, where I think the vast majority of family law matters in general are adjudicated is between the regional court of the Magistrates Court and the district court of the magistrates court, and I'll explain to you why I say that a little bit later, because I'm sure a lot of the attorneys in today will say, but family law matters do not take place in the civil district courts or the magistrates court. So what are the courts really tasked with dealing with in terms of family law matters? And I think let's start with the High Court and let's move down from there. The High Court deals with divorce. It deals with interim matters, Rule 43. It deals with parental responsibilities and rights. And then, very important in terms of the High Court, it has inherent jurisdiction to adjudicate matters. It can entertain any matter it deems appropriate. In other words, it does not need to be granted authority to deal with a matter by any piece of legislation by virtue of the way that it was constituted in terms of the Superior Courts Act, etc. It has inherent jurisdiction to adjudicate any matter it deems appropriate. That does not necessarily, ladies and gentlemen, mean that it can, but it may not, in certain circumstances, elect to adjudicate matters. And I suppose a very good example of that would be maintenance or domestic violence, where you specifically have a court that has been ring-fenced and identified to deal with these types of matters, and it is therefore very unlikely that a High Court will deal with things that would generally be adjudicated in domestic violence court or maintenance court. Notable exception, obviously, your interim maintenance and your Rule 43s and issues incidental to a divorce, obviously. Then we move on to the magistrates court, the regional court. The regional court can deal with divorces, and it can deal with interim matters incidental to divorces. In the regional court, we sit with Rule 58, which is really the equivalent of Rule 43 in the High Court. Since the magistrates court is a creature of statute, it does not have inherent jurisdiction such as the High Court has. We have to be aware that it needs empowering legislation to do anything, and the legislature was quite clever when they amended the Magistrates Court Act, and they took a real catch-all approach, and in section 29(1) cap B of the Mag Court Act, they said that, well, when dealing with a divorce, a regional court has the same powers as the High Court. So the regional court, when sitting as a divorce court, has all of the same powers as a High Court and could almost be seen to share by proxy a delegated type of inherent jurisdiction to adjudicate on matters relating to the divorce itself in the regional court. Then we move on to our district courts under the magistrates court, and as I mentioned earlier, it's very unlikely that you will see family law matters being adjudicated in the normal district court. You have specialized courts falling within the seats of the various district magistrates courts that deal with the specific subject matter related to their delegated tasks. And the three most prominent ones, obviously, are the Children's Court, the Maintenance Court, and the Domestic Violence Court. And they find their authority to exist, their jurisdiction, their constitution, all the rest, in their various items of legislation. And specifically, we look at the Children's Court, which is established in terms of the Children's Act, the Maintenance Court, which is established by the Maintenance Act, and the Domestic Violence Court, which is established by the Domestic Violence Act. Each of these courts have their own specific quirks and unique characteristics, which we will look at a little bit later. If time permits and if there is sufficient interest, we will look at going through some of the forms that you need to fill in to commence litigation in these various forums. However, do bear in mind at all times when litigating in these forums that they are constituted under the district court of the magistrate's court, and where the empowering legislation does not specifically deal with any particular issues, the magistrate's court rules would still apply. A very, very good example of that, ladies and gentlemen, is the very, very recent judgment which Raquel dealt with in our case law wrap-up, where a children's court matter was taken on an urgent appeal, or an application was launched at least, for execution of an order pending an appeal. And the court said, well, actually, the magistrate's court has its own provisions in terms of Rule 55 for urgent applications to be brought. So you can, as it were, read in the magistrate's court rules to these specific courts as and where appropriate.